Employing workers. In a very small business organization, the owner or owners of the business may do all of the work themselves, but in most organizations, of course, the owners of the business hire other people to do the work for them. It's very important to be clear about whether a contract with a particular worker is a contract of service, according to which the worker is an employee and the business is an employer, or a contract for services, according to which the worker is an independent contractor and the business is a principal. Consider these two types of worker. The person on the top left is employed by a business to work in the telemarketing section of the business. They work there every day, they are paid a salary. The person on the lower right is engaged by the business to come in every month in order to clean the windows of the office building. Now both of these people are workers, both are paid by the business to do the work. But one is an employee and one is an independent contractor. The difference between the two is an important one. Employees are entitled to be paid and to have working conditions that are consistent with the relevant industrial award. Independent contractors charge for their work and are not paid and do not have working conditions that have to comply with an industrial award. Employees are entitled to employer contributions to their superannuation. Independent contractors are not. Employees are entitled to be compensated if they are injured in the workplace. Independent contractors are usually not. When an employer pays an employee, they are expected to deduct from their regular payments an estimate of their income tax liability, and the employer then forwards it to the Australian Taxation Office under the pay-as-you-go scheme that we talked about in an earlier video. When a business pays an independent contractor, however, they are not required to deduct from the payment an estimate of the income tax payable by the worker. Instead, it is the independent contractor's responsibility to manage their own income tax liability. An employer is vicariously liable for the actions of their employees. A business is not vicariously liable for the actions of an independent contractor. And finally, an employee has protection from unfair dismissal. An independent contractor does not. How then do we tell the difference between somebody who is an independent contractor and somebody who is an employee? The traditional test is the control test. If the business has the right to tell the worker not only what to do but how to do it, the worker is an employee. In Narich and Commissioner for Payroll Tax from 1983, a worker was engaged by Narich as an instructor in a Weight Watchers program. The written agreement clearly stated that the worker was an independent contractor. However, it also stated that the worker had to comply with a practice manual issued by Narich. The Commissioner for Payroll Tax insisted that the worker was an employee and that Narich was therefore obliged to pay payroll tax. The court decided that in light of the degree of control exercised by Narich over the worker was an employee. So this case demonstrates, first of all, the control test, that the courts will consider the extent of control by the business over the worker. But the case also illustrates the fact that it is not necessarily up to the business to decide whether or not a particular worker is an independent contractor or an employee. The agreement may describe the worker as an independent contractor, but if the court is satisfied that the worker is really an employee, then that is their legal categorization. In other words, it is up to the court to decide whether a worker is an employee and not necessarily up to the business itself. In Zooey and Worth Brothers, Zooey was a circus trapeze artist employed by Worth Brothers. When he was injured, he claimed workers' compensation. And Worth Brothers resisted the claim, arguing that Zooey was an independent contractor and not an employee, and you will recall that independent contractors are not entitled to workers' compensation. Worth Brothers argued that the control test should be applied, and that since they had no actual control over how Zooey performed his act, he was not an employee. The court, however, acknowledged that while the degree of control was an important consideration, it was not the only consideration, and it decided that in the circumstances, Zooey was an employee. Today, courts acknowledge that while the degree of control is an important factor, it's not the only factor, and in fact the courts will prefer to look at all of the circumstances before deciding whether or not a worker is an employee. In Hollis and Vabu from 2001, Hollis was injured when he was knocked over by a bicycle courier who worked for Vabu, which traded as crisis couriers. Hollis could not identify the individual courier who injured him, but he recognized the courier's uniform, so he commenced legal proceedings against Vabu for compensation. He argued that as the courier's employer, Vabu was vicariously liable for the courier's actions. Vabu argued that their couriers were actually independent contractors and not employees, and that therefore Vabu was not liable. Vabu claimed that it did not control how the couriers performed their duties, and that because the couriers were obliged to bear the costs of their own vehicle maintenance, they were really independent contractors. The court rejected the control test in favor of an approach based on economic reality. It referred to the fact that the couriers were not skilled workers engaged in an independent enterprise, that the couriers wore a crisis courier's uniform, that the payments to the couriers were set by Vabu rather than negotiated, and the court decided that the courier was an employee rather than an independent contractor. Vabu was therefore vicariously liable for what the courier had done and had to pay compensation to Hollis. So the sorts of things the courts will look at. They'll look at the nature of the worker's tasks. If the worker is given a general task to do and then left to decide how best to do it, it's more likely that they're an independent contractor. But if they're given a set of very specific tasks and closely monitored, then they're more likely to be an employee. They'll look at how the worker is paid. Does the worker decide how much to bill the business, or does the business pay the worker at a regular rate set by the business? The courts will consider who sets the hours of work. Does the business tell the worker when they should show up and when they should finish, in which case they're more likely to be an employee? Or does the worker decide when they do the actual work, in which case they're more likely to be an independent contractor? The courts will consider who provides the tools and maintains the tools. So an employee will usually be provided with tools by the business, but an independent contractor will usually use their own tools. And finally, whether the worker is authorized to delegate. An independent contractor is entitled to get somebody else to help them or even to do the work for them, as long as the work gets done. But an employee, of course, has to do the work themselves. Employers and employees also owe each other duties and obligations. An employer owes an implied duty to their employees to provide for their safety. That is, to employ competent and qualified co-workers, to provide a safe place of work, and to exercise reasonable care in the supervision of the place of work. An employee owes the employer an implied duty to faithfully and obediently carry out the tasks that are assigned to them. They also owe them a duty not to disclose the employer's trade secrets and other confidential information, not to help the employer's competitors, not to conceal relevant information from the employer, and not to take advantage of information and opportunities for their own personal benefit.